Welcome everybody to the first edition of the Squire Patton Boggs Lending Icons podcast. Here, of course, with a legendary icon on my back wall, but we've got two fantastic icons in the lending industry, financial services professionals with experience going back 30 years. My name is Eric Troutman. I'm a partner here at Squire Patton Boggs and also a litigation specialist. But today's show does not have to deal with litigation at all. Rather, we're going to talk about steps that lenders can take in these distressing times to keep themselves safe and avoid the prospect of loss and litigation. Let's introduce our panelists. First, we have Mike Forshey. Mike, welcome to the show. Can you tell the audience a little bit about your experience?
Sure, Eric. Thank you very much. So I'm a trial lawyer in the Dallas office of Squire Patton Boggs, also the office managing partner. I've been doing trial work for almost 40 years now, and for 35 of that, I've done financial services litigation. Started out doing that actually in the savings and loan failures back in the mid-'80s, and have continued to do that ever since.
And our second lending icon, the head of Squire Patton Boggs' robust real estate practice globally, John Thomas. John, welcome to the show.
Thank you, Eric. Great to be here.
Can you tell us a little bit about your background, John?
Oh, sure. Now, 30 years I've been practicing real estate law after several years working on the development side when I tried to avoid being a lawyer. A lot of work representing both lenders and borrowers, developers in the development of real estate, financing acquisitions, financing construction. And, looks like I may be heading into my fourth real estate finance downturn. Fingers crossed that it's a V-shaped recovery and we won't have too much workout activity to keep us busy, but we're ready for it if it happens.
Indeed. So between Mike and John, we've got a tremendously powerful panel for you today. And our topic, managing distressed credit facilities to maximize recovery and minimize lender risk. First topic, folks, lender liability has been around for decades. Why are we focused on it now? Mike, can you start us off?
Sure, happy to, Eric. It's a good question, and unlike a lot of the questions that are going to be posed today, it actually has a pretty direct answer. Anytime you see disruption in the economy, you end up with credit facilities that are distressed, non-performing. So much like the financial crisis of 2008, the COVID-19 disruption has had the same impact with regard to credit facilities. So lender liability has been around obviously for a long time, but the amount of lender liability claims and cases dramatically increases when you have a disruption like this in the economy. Everybody, I think, knows about the CARES Act that's been put in place. Now, that was done with the intent and the purpose that you'd have borrowers and lenders working together, a period of cooperation, if you would. And certainly, to some extent, that's the case. But a financial disruption like this is going to have ripple effects. And we're going to continue to see the impact of that down the road. And the CARES Act is really more focused on stabilizing the economy rather than stimulating it. So we're going to see a true onslaught, I believe, of lender liability litigation coming from this.
From a real estate perspective and as a real estate focused lending attorney, why are we focused in this time frame on lender liability?
I think in this case, Eric, it's different from any other downturn that I've ever experienced. This is one, it's more across the board, across all classes of real estate. It has no geographic boundaries. We're seeing trouble everywhere. And the cause is so different. Historically, loan workouts in real estate are a result of overbuilding, too much supply. This is an external cause that we've never seen. And frankly, it's going to require business judgments by lenders and borrowers where their approach to how to solve the problems may differ. And I think when you have that conflict of business judgment is where you risk issues of lender liability even more so than we may have seen in past downturns.
All right, well, let's zoom out and get metaphysical for a second. What is lender liability? I mean, how can a lender be liable and for what?
Yeah, so Eric, let me go ahead and jump into that. So lender liability is a very broad concept and topic. The way I look at it from a litigator standpoint, I put it into three buckets. One would be borrower claims based upon a lender's failure to perform or breach of contract. Okay, lender has an obligation to lend or advance money. Lender has an obligation to give approvals in a timely manner. Lender doesn't do that. Borrower brings claims. Those are pretty simple, pretty straightforward, although they can be dramatic. Second bucket is where lenders exercise control over the borrower's business, or the borrower's collateral. And there are two pieces to that bucket. The first piece is where a lender exercises control, and that control impacts a third party. And the third party actually then has a claim against the lender. So let me give you a quick example of a situation like that. So you've got a lender, and the lender tells its borrower that I think your management company is doing a terrible job. You need to fire them and hire a new management company. And this is the one I want you to hire. As it turns out, the borrower has a contract with that management company. And by terminating that contract, it's breached. Borrower turns around and says, okay, I'm going to sue you, lender, because you tortiously interfered with my relationship with the borrower. So that would be a third party claim coming against the lender. So the last bucket, which is the bucket we deal with more than anything else, it's where a borrower exercises control again over, a lender exercises control again over a borrower, the borrower's business or collateral, and makes decisions that impact or impair the borrower or the collateral, at least in the borrower's mind. That's the biggest bucket that we deal with. And that's kind of the focus of usually the defense we have when you have an onslaught of lender liability litigation like this.
Not only in this context, not only is the lender potentially going to be out some amount of money that they've lent, I mean, they are actually potentially going to be liable for steps that they have taken on collateral to some third party that wasn't even a party to the original transaction.
Yeah, that's exactly right. So, in a down market, an economy which results in collateral being worth substantially less than it was otherwise, you've got a lender who's already in a hole, right? What you don't want to do is have the lender dig a bigger hole by creating additional independent liability, either where third parties are bringing claims or the borrower has additional claims.
Eric, it's John. I want to weigh in here, though. I mean, what Mike says is well and good, and I understand it. But the flip side is, as a lender, you can't stand by and watch your collateral continue to deteriorate in value. And that's where the tension comes. I mean, there are certain we could create as lawyers very simple bright line steps where there's zero risk of lender liability and just follow your loan documents, the loan's in default, accelerate and foreclose. The problem is that almost guarantees a loss in a lot of occasions. And the nature of loans is, especially in a situation now, you look to we're looking to manage and obtain a better outcome through loan workouts. We want to enhance the value of our collateral. So that requires, being proactive, being active as a lender and applying your judgment to it. So, I hope, everything Mike says is absolutely right, but there's, I think, a continuing balance between watching your collateral, your source of repayment, continue to deteriorate in value versus the risk of lender liability. And I think that's what, we can dig into here and try to navigate through that rather tortured path.
Foreclosure is failure. We all know that. And before we dive into the ifs and whens and the tugs and pulls, let's talk about a couple of things concrete. In this environment, loan collateral is undeniably going to be the primary source of loan repayment for many companies that are failing. What can a lender do safely right now to make sure that they're in the best position to capture whatever recovery they can from that collateral? Mike, what's your view on that?
Yeah, so there are a lot of things that lenders can do now. If you're looking at the collateral as your primary source of recovery, you need to check out your loan documents. Do you have the collateral properly described? Do you have the security interest perfected? Do you have the right priority? If the collateral is tangible, you might want to go out and actually look at the collateral. Go out, view it. Has it been impaired? Is the borrower maintaining it properly? If it's real property, there are all sorts of things you might want to do. You might want to actually go out and update your title search to make sure that there hasn't been an impairment there. Update UCCs to make sure that there aren't other liens that have come in. Check taxes to see what the status of that is. Also, if you've got property that needs to be insured, most of which does, you want to make sure that there's insurance out there that's already in place. And of course, if the borrower has failed to maintain insurance, lender documents almost always give the lender the right to go out and secure that insurance to protect its collateral.
So those are the basic steps that everyone should be doing, preparing during this time of cooperation or a time when steps on collateral are going to have to be taken. But John, you were saying that a lender can be more aggressive and that there might be additional steps that can be taken to better protect itself. Tell us about those.
Now, in that case, I think, the first thing, as a lender, you want to get in and understand, why is your asset in trouble? What happened to your collateral? One workout officer told me a long time ago, I need to know, is my borrower part of the problem or part of the solution? And that really means digging in. Is, in the case of real estate, is it a bad location, a bad market, which are not necessarily borrower caused other than the original decision? Or is it bad operations, which can be part of the problem being your borrower? Has the property been maintained properly? Do they have the right go-to-market strategy? In real estate, most of the problems are caused by a lack of occupancy. Is their pricing wrong? Are they missing amenities at the asset? What is the competition doing that you aren't doing? It's really digging in and understanding fundamentally why the asset's in trouble that then leads you to the next steps. It's also, as Michael pointed out, where we'll get in trouble too when we start making those judgments and start working on a plan of how to rehabilitate the asset.
John, help us to understand, what steps can be taken? Let's assume now we're in an event of default and something has to happen. Do we take action to protect the collateral immediately? How do we minimize risk of liability while we're doing that, from your view? Recognizing we'll get Mike's view in a second.
From my point of view, to me, it's about knowledge and documenting the information you have and documenting the basis for the judgments you make. It's, understanding the market. So if you're looking at evaluating the assets placed in the competitive environment, do you get a market study for certain products like hospitality, senior living, things like that? Market studies can be very helpful to understand the competition and where your asset fits in the marketplace. Inspections of the property, the physical status of the property, and documenting whether it's been maintained properly or not. To me, it's about establishing a framework and a history of rational decisions on the part of the lender, not acting impulsively, not acting arbitrarily, and really a fact-based decision process that professionals in the industry can look at and say, there's a good business judgment behind what you're recommending here or what you're asking the borrower to do.
John, does your group help provide guidance around making those decisions and kind of coming up with the right workout strategy?
No, absolutely. Our group and, our friends like Mike and our other litigators, we work together to minimize risk. We work on the strategies and we take the advantage of our experience. You heard between Mike and I, there's like 70 years of experience doing this thing. We've seen plenty of mistakes made, and we can relate with our lender clients the best practices on ways to not only get to good decisions, but also to mitigate risk.
Throwing it over to you, what are some of the pros and cons that you see for taking action to protect collateral?
Yeah, so John's exactly right. Lender just can't sit back and watch their collateral be wasted or deteriorate or not be maximized. I get that. But you've got two different situations here. First, you've got certain rights under your credit facility that will allow you to do various things with regard to the collateral. It could be monitoring, it could be approving certain things. And as long as you are exercising those contract rights, appropriately, you're not going to get really into any trouble. Maybe with two caveats I'll throw out right now. So even if you have contract rights, there are some states, New York, for example, that has an implied duty of good faith and fair dealing, which means when you exercise a contract right, you still have to do it in good faith. Also, if a credit facility has been in place for 2-3 years, you may get a course of conduct, which a borrower could then come back and argue, okay, you never enforced this covenant before, financial covenant. It came up several times, it was breached, you didn't do anything. You shouldn't go in and enforce it now and try to take action. So, generally you can enforce those contract rights with, again, a couple caveats. The place that I see lenders get into trouble really is where they are trying to take action where they don't have a contractual right to do that. And that's still, something that a lender needs to consider doing if it's going to protect the collateral and maximize the recovery. But it's the way you go about it, right? If a lender comes in and is really heavy-handed, saying, okay, you can't operate under this budget anymore. You need to stop spending money on all this landscaping you're doing, and you need to turn all your dollars and focus on marketing and the other. If you dictate as a lender that that's what the borrower has to do, and the business declines or fails, I guarantee you, no matter how well-intentioned the lender was, the borrower is going to say, hey, it wasn't doing great at first, but if you give me a little time, I'd have pulled it out and we would have done fine. You forced me to do things that caused the business to fail. And that's where the lender liability types of claims I'm talking about come from.
Mike, do you see with lenders, though, a reluctance to get involved with their borrowers' business decisions generally? Or do you think that lenders are generally chomping at the bit to take over and start micromanaging these operations?
I think the last thing that a lender wants is to micromanage. And when a credit facility is operating well, lenders can and should, I think in all respects, stand back, let the borrower do what he does well, operate his business, whatever industry or type of business that is. Lenders don't want to micromanage that. Obviously, they'll want to oversee certain things like how the money that they're advancing is being spent. Is it being spent properly, with regard to the property, or is it being used to purchase, a nice home out in Santa Monica? So, you have to obviously watch that. But lenders don't want to micromanage. The challenge comes in when you have a downturn, an impact, whether it be the 2008 financial crisis or something more unique like COVID-19, where you have an impact on businesses and loans become non-performing. Everybody is challenged in this particular environment we're in, this particular economy. So lenders, I think, can be helpful. They can go in and they can use their knowledge base. They can bring in consultants, in fact, to maybe assist the borrower. But when you provide information like that to a borrower, the lender needs to, for the most part, offer that. Don't dictate it. Don't be heavy-handed about it. But here's a different strategy. You're going about this all wrong. That lender may have multiple properties in areas where the borrower doesn't have that knowledge base. The lender can bring something extra to the table. The lender may also have relationships with great consultants who can give the borrower some direction. So what you want to do is you want to guide the borrower rather than force the borrower. Because once you start forcing, no matter how well-intentioned it is, if it goes wrong, there'll be litigation.
Mike, I understand. I just want to follow up on that. I understand. And look, we also know we can get sued for most anything these days, but not every borrower is reasonable. Not every borrower is rational. And a lot of them come into a workouts with immediately an us versus them mentality. And I can have 5 consultants tell me that their approach to marketing or the way they manage the property is wrong. And I can have their 20 competitors all doing it differently. And they'll still say, no, this isn't the right way to do it. But again, as the lender, I agree. I'd rather nudge and encourage them to do it and not make them do it. But again, if my choice is making them do what I think is best for the asset versus watching it to continue to deteriorate in value, I mean, what more can I do at that point?
No, it's a fair comment, John, and I think that's where the push and pull comes in all of this. I think if a lender finds himself in a position where they're dealing with a difficult borrower, one that just doesn't want to listen, you've got multiple options that I think you need to explore. First, I do think you go in and you make recommendations, you document all that, right? So if you ultimately get in litigation, you can show that you came in with good intentions. If the borrower just thumbs his nose at you and says, I'm going to do what I'm going to do, obviously you have options under the credit facility to foreclose. Again, that may fix a loss, which you don't want to do. You've got the potential of filing for a receivership. Now, receiverships oftentimes sound good, but as a practical matter, they can be really difficult. You also have the option of potentially pushing that borrower into a bankruptcy, which again may not be any different than fixing the loss that you had based upon a foreclosure. So I think you have to explore all those things, and depending upon the size of the credit facility, the type of business, it's not one size fits all. You may want to explore all those options to see what makes the most sense.
Sure. Let's also talk about using forbearance agreements as a way to create, a better shield for the lender. I found, in the case of, you made the correct point earlier that, exercise the rights you have under the loan agreement. And no one questions, in the context of negotiating a loan agreement and making the initial loan, the lender negotiating for certain rights. But now we're into workouts. We don't have all the rights we want to, but we would like the borrower to take certain actions. I found that in the context of a forbearance agreement where the lender is agreeing not to exercise its remedies, not foreclose, not wipe out your equity, give you more time, sometimes even reducing interest rates or changing payment terms, that in that context, we can direct the borrower to take actions that we think are better for the collateral. I mean, is that a good alternative, and does that provide more protection for the lender that way?
Yeah, John, it's a great point, and I think that is one of those options which I didn't throw out there, but probably one that may be most efficient. Now, if you're going to go ahead and forbear, you're going to extend the credit facility, or you're going to give something up, you have the opportunity to get things in return. And if in the original credit facility, you didn't have the right to approve budgets, or you didn't have the right to do this, you can actually amend the credit facility through the forbearance agreement to get some of those rights. Now, I think that it's important there to make sure whatever you do, you document, right? You don't want to go into a forbearance agreement and give up something, give the borrower some additional rope, if you will, and not include the additional things you need, but simply tell the borrower, okay, we're going to give you the forbearance, but we want you to allow us to have more involvement, because that being undocumented is its own set of problems. So using the forbearance agreement for that is a great vehicle. You also have another option too that sometimes comes before the forbearance agreement, and that's a pre-negotiation agreement, right? So if you see a borrower who may not be in default yet, but the handwriting's on the wall, and that borrower is coming to you saying, okay, well, it doesn't look great. I may need some concessions here. As part of a pre-negotiation agreement, you can get some of those concessions, but you also build into both a pre-negotiation agreement or a forbearance agreement releases. You're giving something up. You're giving consideration, right? So you want to get releases up through the date of that agreement. Some states will limit what you can do in the future, but you get as much as you can. That way you kind of wipe the slate clean. One of the other great benefits about pre-negotiation and forbearance agreements is you can come in and you can document every default, whether it be financial, covenant, or otherwise. And basically the borrower's agreeing to that. So if things don't go well down the line and you actually have to get into litigation, I can walk in with that forbearance agreement, and all those things that I would otherwise be required to prove, I've got in one document. It's all encapsulated together, and it's really helpful to have that. But again, to your point, yes, you can get some great concessions, you can get some additional rights, and it's probably one of the most useful tools that a lender has.
So John, I mean, the forbearance agreement, it sounds great, but is there any downside? And do these borrowers really just roll over and give you everything that you want in the first pass?
We should live so long. No, it's like any other negotiation. And to me, it also goes to your approach. Mike can speak to this better, but in my experience, where you have lender liability is where lenders get heavy-handed, where they, become arbitrary. And I have found that it's really hard in the workout business for these things not to, in many cases, they become personal. There's a borrower that is emotionally invested in a project that they developed and vouched for, and they're seeing that investment waste away. Their equity is the first thing that's gone. The lenders see the loss to the bank. They're not being repaid. And quite often in those scenarios, you see their colleagues being laid off because the banks are distressed as well when they have a lot of loans going bad. And a lot of these become personal. And I think, in my experience, that's a lot of what happens here. And, to me, it's all about, when we're counseling our clients on this, whether it's a borrower or a lender, it's like, let's stick to the business and let's really evaluate the business and be focused on what are the problems, what is solvable, what isn't solvable, what does the borrower have to contribute to the solution, what does the lender have to contribute to the solution. Because the reality is, in most of these workouts, both sides have to contribute something to it, and there has to be that give and take.
Calculated guy, how do you cut through the emotionality and the hurt feelings in a workout process?
I think that's our job. We're the ones that don't have an emotional stake in it. So it's, constantly getting our client focused on the business issues and to set aside the emotionality of it.
Well, you guys are vastly experienced, of course, titans of the financial services sector, and I know that you are always happy to help our clients and answer some of these questions. But here at the end of the podcast, the end of the show, I wanted to give you each a minute or two. Give us your final thoughts. What are your closing remarks here, and why should folks be reaching out to you? John, let's start with you.
Simply, we try to bring a disciplined approach to the workouts. Again, focusing on that last point. We try to understand the problem, we look for the solutions, and we try to find creative middle grounds that serve the interests of both sides. And that's our role. That's how we're productive. That's how we're constructive to the process. There's no one size fits all solution, and we look for solutions.
Mike, last word. What do you have for us?
Yeah, so I agree with certainly everything that John said. We also have a wealth of experience. We've been there, done that. We've been through multiple downturns. We deal with these issues on a regular basis. The other thing that I think we offer to clients, which is critically important, and that is a team approach, right? When matters come up, when disputes arise, it's not just the litigator stepping in on his own, even if he's experienced, to try to work through this all by himself. You get an experienced and very capable real estate lawyer like John, who steps in and works side by side. And the things you can accomplish that way are much greater than trying to focus on it just from a litigation or just from a business standpoint. There's always that middle ground that you're trying to achieve that really gets the client the result they're looking for.
Deep bench, deep experience, and a team approach. That is how you become a financial services icon. The takeaway is clear, folks. The lenders exercising control over a borrower or collateral can be critical, especially in times like these, to maximize recovery. but a lender must always carefully navigate the type and extent of control to manage the risk that may come along with it. We hope you enjoyed today's show, the first episode of Squire Patton Boggs Financial Services Icons. I was your host, Eric Troutman. Talk soon.